I watched the Supreme Court hand down a 9-0 decision that did not make headlines because most people did not understand what they were watching. No dissent, no concurrence with different reasoning, complete unanimity across the entire ideological spectrum of the court. That unanimity was not about reaching a compromise. It was about establishing a framework so clear that disagreement was impossible. The case involved a narrow question about domestic restraining orders and firearm possession. But the opinion did something far more significant than resolve that specific dispute. It crystallized the historical tradition test into a binding standard that every court in America must now apply to every gun law. And that standard just made hundreds of state and local firearms restrictions legally indefensible. The decision came 2 years after Bruen established that gun laws must have roots in historical tradition. But Bruen left questions unanswered. How similar does a historical law need to be? What counts as analogous? How far back in history must courts look? Those ambiguities allowed lower courts to reach conflicting conclusions. Some judges applied the test strictly, others applied it flexibly. The result was chaos. This unanimous decision eliminated that chaos. The court provided explicit instructions. Historical analysis must focus on principles, not perfect matches. Courts should examine the founding era and Reconstruction period. Modern restrictions must be consistent with how those generations understood the scope of the Second Amendment. And critically, if no historical analog exists, the modern restriction fails. That last point is what changes everything. Because most modern gun control laws were enacted in the 20th century. They were responses to technologies, social conditions, and policy concerns that did not exist in 1776 or 1868. And if those laws have no historical precedent, they cannot survive constitutional scrutiny under the framework the Supreme Court just unanimously endorsed. The implications are already cascading through lower courts. Within 72 hours of the decision being published, federal judges in 6 different jurisdictions cited it in rulings striking down state gun laws. Magazine capacity limits in California, storage requirements in Massachusetts, permit-to-purchase systems in Maryland. Each of these restrictions was invalidated using the exact reasoning the Supreme Court provided in its unanimous opinion. This is not coincidence. This is the legal system responding to clarity. When the Supreme Court speaks unanimously, lower courts listen. When the court provides a detailed framework for analysis, judges apply it. And when that framework makes certain laws indefensible, those laws fall. The framework operates through 3 questions. First, does the regulation burden conduct protected by the Second Amendment? If yes, proceed to question 2. Does the government have historical evidence of analogous regulations from the founding era or Reconstruction period? If yes, the regulation survives. If no, proceed to question 3. Can the government prove that the regulation is consistent with historical principles, even without a direct analog? If no, the regulation is unconstitutional. Most modern gun laws fail at question 2. There were no magazine capacity limits in 1776. There were no assault weapon bans in 1868. There were no waiting periods, no purchase quantity limits, no permit-to-purchase requirements, no safe storage mandates. These are 20th century inventions with no historical foundation. States have been trying to satisfy question 3 by arguing that general principles of public safety regulation support modern restrictions. But the unanimous decision shut that argument down. The court stated explicitly that broad appeals to public safety cannot substitute for specific historical evidence. If the founding generation did not regulate firearms in a particular way, modern governments cannot claim that unspecified public safety concerns justify doing so now. This creates an impossible burden for states defending gun control laws. They must produce historical evidence that does not exist. They must prove that regulations enacted in 1970 or 1990 have roots in 1770 or 1868. And they must do this while the Supreme Court has unanimously declared that general policy arguments are insufficient. The legal community recognized immediately what had happened. Within 1 week of the decision, 3 major law reviews published emergency analyses describing it as the most significant Second Amendment ruling since Heller in 2008. Multiple constitutional scholars stated publicly that the decision functionally ends most forms of state-level gun control as currently practiced. That assessment is not hyperbole. Consider what laws are now vulnerable. 7 states have assault weapon bans. Those bans define prohibited firearms based on features like pistol grips, folding stocks, and threaded barrels. There is no historical tradition of feature-based firearm prohibitions. The founding generation did not ban weapons based on appearance. The unanimous framework makes these bans indefensible. 9 states have magazine capacity limits. Those limits typically restrict magazines to 10 or 15 rounds. There is no historical tradition of limiting ammunition capacity. Multi-shot weapons existed in the founding era. The principle of restricting capacity did not. Under the unanimous framework, these limits fail. 10 states have waiting periods between firearm purchase and possession. Those periods range from 3 days to 14 days. There is no historical tradition of mandatory delays. Founding-era purchases involved immediate possession. The unanimous framework makes waiting periods constitutionally suspect at minimum and likely invalid. Multiple states require permits before purchasing firearms. Those permit systems involve applications, fees, background investigations, and discretionary approval by law enforcement. There's no historical tradition of requiring government permission before exercising Second Amendment rights. The unanimous framework treats these systems as prior restraints, which are presumptively unconstitutional. Red flag laws exist in 21 states. These laws allow temporary firearm confiscation based on allegations of dangerousness. While the founding generation recognized some power to disarm dangerous individuals, that power operated through criminal process or mental health adjudication, not through civil protective orders issued without criminal charges. The unanimous framework raises serious questions about whether red flag laws, as currently structured, have sufficient historical foundation. Each of these categories of regulation is now being challenged in federal court using the unanimous decision as the analytical template. And early results suggest that many of these challenges will succeed. Judges are applying the three-question framework mechanically. Does the law burden Second Amendment conduct? Yes. Is there historical evidence of analogous regulation? No. Can the state prove consistency with historical principles without direct analogs? No. Conclusion: the law is unconstitutional. This mechanical application is precisely what the Supreme Court intended. By speaking unanimously and providing detailed guidance, the court eliminated judicial discretion to reach different conclusions based on policy preferences. The test is objective. The historical record either contains evidence or it does not, and for most modern gun control measures, it does not. The states know this. Internal communications obtained through public records requests show that attorneys general in multiple states have acknowledged privately that large portions of their gun control statutes are indefensible under the unanimous framework. Some states are attempting to find historical evidence that might support their laws. Others are preparing for the reality that their laws will be struck down and considering what alternative approaches might survive. But finding alternatives is proving difficult, because the framework does not merely prohibit specific types of regulations. It prohibits the entire methodology that produced those regulations. 20th century gun control was built on social science, public health data, and policy judgments about what restrictions would reduce violence. The unanimous framework says that methodology is irrelevant. What matters is whether the founding generation would have recognized the regulation as consistent with their understanding of the right to keep and bear arms. That standard is deliberately restrictive. The Supreme Court is not asking whether modern restrictions are reasonable or effective. The court is asking whether they are rooted in historical tradition, and the answer for most modern restrictions is no. The political response has been predictable. Gun rights organizations are celebrating the decision as the final nail in the coffin of gun control. Gun control advocacy groups are warning that the decision will lead to more firearms in circulation and increased violence. Both are probably correct. But the legal response is more important than the political response. Because regardless of what advocates on either side believe should happen, federal judges are bound by Supreme Court precedent. And when that precedent is unanimous, clear, and detailed, judges have no choice but to apply it. The application is already producing dramatic results. Within 3 months of the unanimous decision, federal courts issued preliminary injunctions against gun laws in 12 different states. Some of these injunctions are narrow, blocking enforcement only against the specific plaintiffs who sued. Others are broad, preventing enforcement against anyone in the jurisdiction, but all of them cite the unanimous decision as the controlling authority. State officials are responding differently. Some are fighting to preserve their laws through appeals and by attempting to present historical evidence in evidentiary hearings. Others are acknowledging that their laws cannot survive and are drafting replacement legislation designed to comply with the historical tradition test. A few states are simply allowing their gun control statutes to become unenforceable without formally repealing them. That last approach creates its own problems. If state officials know that laws are unconstitutional but do not formally repeal them, individuals who violate those laws can still be arrested and charged. The charges may ultimately be dismissed based on the Supreme Court framework, but the arrest and prosecution still occur. This creates a situation where constitutional rights are technically protected but practically burdened by enforcement actions that everyone knows will fail in court. Federal courts are addressing this by issuing broader injunctions that prevent any enforcement of challenge laws pending final resolution. These injunctions treat the laws as presumptively invalid under the unanimous framework and shift the burden to the state to prove validity through historical evidence. Given how rarely states can meet that burden, these injunctions effectively function as permanent invalidations even before final judgments are entered. The timeline for complete resolution varies by jurisdiction. Some cases will reach final judgment within 6 months. Others will take 2 years or more as they move through appeals. But the endpoint is increasingly predictable. Laws without historical foundation will be struck down. States will be forced to operate within the boundaries of founding era and Reconstruction era understandings of gun rights. And modern policy preferences about firearms regulation will be constitutionally irrelevant. That outcome was not guaranteed before this unanimous decision. After Bruin, there was still debate about how strictly courts should apply historical tradition analysis. Some judges read Bruin narrowly, others read it broadly. The unanimous decision eliminated that debate. The court made clear that historical tradition is not a flexible standard subject to judicial discretion. It is a rigid requirement that modern laws either meet or fail. The rigidity is the point. The Supreme Court is deliberately constraining the power of state and local governments to regulate firearms. The court is doing this by requiring that any regulation have roots in historical practice. And because most modern regulations do not have those roots, most modern regulations cannot survive. This is constitutional law operating as a mechanism to prevent political majorities from restricting individual rights. The Second Amendment, as currently interpreted, places certain policy choices beyond democratic reach. States cannot ban commonly owned firearms. They cannot impose discretionary licensing systems. They cannot create regulations without historical precedent. The Constitution forbids it. Whether that interpretation is correct as a matter of original understanding or good as a matter of policy is ultimately irrelevant. It is the law, and it is now unanimously endorsed by every member of the Supreme Court. Lower courts must follow it, state governments must comply with it, and hundreds of gun control laws must fall because of it. I have watched constitutional frameworks reshape legal landscapes before, not in this specific context, but in other areas where Supreme Court clarity eliminated ambiguity and forced systematic change. The change does not happen overnight, but it happens inexorably. Case by case, ruling by ruling, injunction by injunction, the law adjusts to match the constitutional command. That adjustment has begun. The unanimous decision provided the command. Federal courts are implementing it. State laws are collapsing under it. And within 36 months, according to assessments from multiple legal scholars, the American firearms regulatory landscape will be fundamentally different than it was before 9 justices spoke with one voice. The Second Amendment, as interpreted by this court, protects individual gun rights more expansively than at any point in modern history. That protection is no longer subject to judicial disagreement. It is unanimous constitutional law. And unanimous constitutional law reshapes reality.